After a person passes away, the law requires all of their possessions to be distributed to their heirs according to their last will and testament. This usually goes pretty smoothly, but not always. Attorney Jim Higgins with the Higgins Firm recently stopped by to talk about why someone would challenge the validity of a will and when a will can be thrown out. Take a look. All right, we've got Jim back in the studio with us. Great to have you back.
Thank you.
All right, we're talking a little bit about heirs who are unhappy with their will. A lot of times they will ask, can I challenge the validity of a will? So talk a little bit about when you see this happen. Is this common?
Yeah, we get this question a lot in our estate practice and wills practice where people want to know if they can challenge a will. And then, of course, sometimes we talk to them and it's probably not a good idea, and sometimes it is, and it can go on through all the way to litigation. Where we see it most is when there are changes to the will that come towards the end of someone's life, that when somebody thinks that that usually a parent or a grandparent, that they were tricked or pushed or someone really influenced them in doing something that loved one wouldn't have done otherwise.
Right. Now, can a court throw out a will, and when can they do that, if they can?
Yeah. Well, they can't throw it out just because no one likes it, right? So there are people who do a will that's completely valid, and they leave everything to someone that nobody likes, and you know what? They can do that. When they can throw it out is when the person made the will, if they didn't know what they're doing. You hear being of sound mind. Well, if they're of unsound mind, a court can throw that out. So if you could prove through a doctor, other friends, family members, that this person just really didn't have the capacity to do it, the court's going to throw that will out. You can also throw it out if there was undue influence on them. And the court will look at a lot of factors in that. They're going to look at who do they leave everything to? Were they dependent on that person? I mean, is that somebody that they felt maybe if they didn't change it, they would have really been in a bad shape?
Right.
Did the people who witnessed the will change, did they benefit from it, or were they impartial? Did the person, when he made the change of will, or she did, was it at the end of their life? Was there some pressure on them that the court thinks that they did this? And if they find that undue influence, then again, the court's going to say, you know what, this will isn't valid. This wasn't what somebody really wanted to do.
Interesting. So what happens then if the will is declared invalid? What happens after that?
Yeah, well, that's one of the first things we look at when somebody calls or comes in and says, I want to challenge this will. Well, we say, all right, well, what happens if you win? Are you going to be better off or worse off? What will happen is if the court throws out a will, they're going to go back to if there was a previous will, they'll go back to that one if it was valid. If not, it's going to go as it would under intestate law, which means, usually to your next of kin. The law sets forth how a estate is distributed.
All right, and I know you can help people walk through this. They can just give you a call, right?
No, sure. They're welcome to call our estate department anytime. We'll be glad to talk to them if they need us for anything related to inheritance or wills or estate planning.
All right, thanks so much.
Thank you.
The Higgins Firm is serving Tennessee. Give them a call at 615-924-8500 or go to higginsfirm.com.